Tutorial video on when a housing provider can enter a residential rental unit. Disclaimer: the information provided in this tutorial video does not and is not intended to constitute legal advice. Instead, all information and content are for general informational purposes only. Question: does my housing provider need to notify me before they enter my rental unit? Answer: yes. In the District of Columbia, all housing providers must follow the law when they want to enter an occupied residential rental unit. Summary of the law. A housing provider must give a tenant written notice at least 48 hours before the time the housing provider wishes to enter the unit, or a shorter period of time as agreed to by the tenant in writing. Except in the event of an emergency, a housing provider may enter a rental unit between the hours of 9 a.m. and 5 p.m., Monday through Saturday, except for federal holidays, or at another time agreed upon by the tenant in writing. Note: the housing provider 48-hour written notice requirement is also applicable to the housing provider's employees, agents, contractors, and realtors. Note: if you report a housing code violation, you cannot unreasonably prevent the housing provider from accessing the unit to fix the alleged violation. Common issues with housing provider entry. Housing provider enters unit without providing proper notice. Housing provider only provides oral notice. Maintenance or property manager enters the unit without providing proper notice. Or, realtor wants to schedule a showing for Sunday or after 5 p.m., or places a lockbox on the unit to permit entry at any time with no notice. What can you do if your housing provider fails to follow the law regarding entering your rental unit? 1. Write your housing provider a letter or email outlining the improper notice entries and informing them that District of Columbia law requires 48 hours written notice before entry. 2. If the letter email fails to motivate your housing provider to follow the law, contact the District of Columbia Office of the Tenant Advocate about filing a temporary restraining order in D.C. Superior Court to prevent further improper entry. A temporary restraining order is a court order to stop harmful conduct. In this situation, the court could order the housing provider to stop improper entries and to abide by the notice requirement. If you have questions or concerns regarding when a housing provider can enter a residential rental unit, contact the District of Columbia Office of the Tenant Advocate.